Welcome everyone. Round two here for us, a couple of us anyway, a few of us. The meeting of the Board of Chiropractic Examiners Fourth Committee is being held by teleconference pursuant to statutory provisions, Government Code Section 11133. The date is Thursday, October 6th, 2022, and the time is 2:36 to be exact. The board's paramount responsibility is to protect the health, welfare, and safety of the public through licensure, education, and enforcement in chiropractic care. Members of the public may address the committee during the public comment session. Public comments will also be taken on agenda items at the time the item is heard and prior to the committee taking any action on said items. Those who would like to provide public comment will be limited to 3 minutes unless in the discretion of the committee circumstances require a longer period. Members of the public will not be permitted to yield their allotted time to other members of the public to make comments. Individuals may appear before the committee to discuss items not on today's agenda. However, the committee may not discuss or take action on these items except to decide whether to place the matter on agenda of a future meeting. Please be aware that this meeting is being recorded. Please turn off or silence all cell phones. We will now take the roll. Dr. Pears, will you take our roll call?
Yes. Dr. Lawrence Adams.
Present.
Mr. Raphael Sweet.
Present.
And Dr. Dave Paris, present. You have a quorum.
Thank you. We're on agenda item 2, a review and possible approval of December 3rd, 2021 committee meeting minutes. We'll now open it for discussion to the committee.
No discussion from me.
Mr. Sweet, Raphael?
I don't have anything. I'm willing to move to approve the meeting minutes from December 3rd.
Second.
All right, thank you. We will now ask the moderator to open up for public comment.
And we've opened up the Q&A feature of WebEx to facilitate public comment. If you have a comment about the minutes, you can look for the question mark in the lower right corner of your computer screen or behind the 3-dot other options if you are on a mobile device, and type the word comment in the text box and click send. The other option to be recognized is to raise your hand by looking for the hand icon in the WebEx app, or if you are a call-in user, you can press *3 to raise your hand. Any comments about the minutes? And I see no request for public comment. Shall I close the Q&A feature?
Yes, thank you.
You're welcome.
Any other further discussion? Hearing none, let's call the vote. Dr. Paris?
Dr. Lawrence Adams.
Yes.
Mr. Raphael Sweet.
Yes.
Dr. David Paris, yes. Motion passes.
Okay, we'll move to agenda item number 3, update on board's enforcement program, and we'll turn the time to Kristen Walker, our executive officer, to bring us up to speed.
Sure, thank you. So for my update this afternoon, I'm going to begin with the expert recruitment. So as you recall, late last year, the board authorized staff to initiate the recruitment process for additional subject matter experts for the board's enforcement program. At this point, we're working to finalize and post that recruitment announcement on our website with a target date of November so that we can then conduct interviews with qualified, or so that the committee can conduct those interviews with qualified applicants early next year and plan for training sometime around spring 2023. As far as legislation affecting the enforcement program, our Sunset Bill, Senate Bill 1434, was signed by the governor on September 27th and becomes effective January 1st of 2023. From the enforcement perspective, what this bill does is strengthen the existing patient notification requirement for licensees placed on probation by the board by removing the exemptions for circumstances when the visit is unscheduled or the licensee who will be treating the patient is not known until immediately prior to the start of the visit. As far as the enforcement unit, we have a few proposed regulations that we're working on. We're currently working to wrap up our delegation of authority and citation program package for submission for review and approval by the department. This proposal clarifies that the assistant executive officer is the executive officer's designee for enforcement purposes, and it also requires licensees to pay any outstanding citation fines prior to the renewal of their license. The other items that are before the enforcement committee, there's the disciplinary guidelines and uniform standards proposal is going to be discussed later this afternoon under agenda item 5. And then the collection of proposals under the Consumer Protection Enforcement Initiative, collectively known as CPEI, they're at various stages of development. The committee will be discussing one of those proposals today under agenda item 6. Then some of the proposals within there relating to the filing of addresses, display of license, and notice to consumer are actually planned to be presented to the licensing committee for review and discussion, as they're related to an issue the committee is already discussing about filing places of practice with the board. And then staff plans to present the remaining proposals to the enforcement committee at upcoming meetings. Also on our regulatory workload is updating the board's record keeping requirements, and that's going to be discussed today as well. Another effort that the enforcement staff has been working on is updating and reviewing their enforcement processes. So this was pretty involved effort, but the enforcement unit staff actually worked directly with the department's organizational improvement office to evaluate the complaint intake, desk investigation, and field investigation processes, and identify some strategies to improve productivity, reduce timeframes, and provide excellent customer service to those involved in our complaint process. We've received the initial recommendations from the project, and the OIO team has developed some process maps for us to incorporate into our existing processes, and we plan to implement those recommendations through the coming year. Also within my update, within the meeting materials, there's a comparison of our statistics for the enforcement program over the past 5 fiscal years. Looking at those statistics, the increases in complaints and citations that you see when you're looking at fiscal years 18-19 and 19-20 are due to failed continuing education audits, which are then referred to enforcement as an internal case. As you'll recall, as we entered in the COVID pandemic, we temporarily paused the audits of continuing education courses just due to the various waivers that were in effect that were providing extensions for completing the coursework. As we prepare to reinitiate those audits, we're expecting to see an increase in complaints, just given the fact that when we conduct audits, we do find violations and they then are referred to enforcement. As far as the other statistics themselves, the number of pending complaints that we have has continued to decrease due to the efforts of our unit on focusing on completing and closing their aged cases. As you can see by looking at these statistics, that number peaked at 594 at the end of fiscal year 19-20, and it was 360 at the end of the last fiscal year. And as we close those complaints, some of them do result in referrals to the Attorney General's office for disciplinary action. So as you can see from looking at those numbers, the number of accusations that we filed and the disciplinary cases pending increased in fiscal year 21-22 due to these referrals. The closed cases then go to the Attorney General's office for filing, and then they also end on the pending disciplinary case numbers. Are there any questions from the committee on my report this afternoon?
I did have one question on the expert recruitment. I think you mentioned that there's going to be some training sessions in spring of 2023. Do you know what those will be comprised of, or who will be conducting those?
So we're going to be working with the Attorney General's office to deliver that training. They have a pretty robust program for training experts on expert witness testimony and report writing. And we may want to have 1 or 2 of the members of this committee join us as well for that training if availability works out for the committee members.
Okay.
Any other questions or comments from the?
I have no questions.
Okay. then we will open it up for public comment.
This is your moderator, and we've opened up the Q&A feature of WebEx to facilitate public comment. If you've got a comment on the executive officer's report or the enforcement program update, you can look for the question mark icon, click on it. In the text box, type the word comment and click send. The other option is to raise your hand by clicking on the hand icon, or you may raise your hand by, clicking on the hand icon, or if you're a call-in user, *3 will raise your hand. And I do not see any requests for public comment. Shall I close the Q&A feature?
Yes.
Thank you.
Since there are no votes or motions that need to be addressed, we'll move on to agenda item 4. Review, discussion, and possible recommendation regarding proposed changes to the record keeping and retention requirements for chiropractic patient records. I'll turn the time over now to Tammy Pitto to bring us up to speed.
Thank you, Dr. Adams. So the board's current record-keeping regulation, California Code of Regulations, Title 16, Section 318, outlines the minimum requirements for documenting and maintaining chiropractic patient records. However, this regulation does not specify the necessary documentation for patient history, complaint, diagnosis or analysis, and treatment, and it does not differentiate between an initial patient encounter and an established patient visit. As a result, the board's enforcement program must rely on experts' opinions regarding the standard of care to support inadequate record-keeping violations in many cases, as the record-keeping requirements are not clearly expressed in the regulation. In addition, this regulation does not specifically address the retention or transfer of patient records following the closure or sale of a practice due to retirement or discipline or the death of a licensee. At the April 16, 2015 meeting, the board approved proposed text to 1, require the unlicensed heir, trustee, executor, administrator, conservator, or personal representative to maintain the records for 5 years. 2, require a licensee or one of these successors to notify the board of a termination or relocation of a practice within 1 month. 3, provide notice of closure or relocation to all active patients via first-class mail. 4, require the maintenance of records for minor patients until they reach age 21 or for 5 years from the date of last treatment, whichever is longer. And 5, refund any portion of prepaid fees within 1 month of termination or transfer of practice. So the committee discussed this regulation at the December 3rd, 2021 meeting and agreed that this regulation does not accurately reflect or delineate the expected record-keeping requirements for licensees. So at this meeting, staff is asking the committee to continue the discussion regarding appropriate record-keeping requirements for licensees, provide feedback and direction to staff, and consider selecting a committee member to work directly with staff on this issue. So I'll turn it back over to the committee now.
Thank you very much. Comments, discussion from the committee?
Well, looking at the, I'm sorry, I had my head down, but I just jumped in.
Go for it.
Looking at the, but I really like the example of how Colorado has that detailed, and it's in the fact that it's, you know, really well defined between it, like an initial patient visit and then, you know, established patient visit. The only thing I think it's a good model to look at, and the only thing is that it's prescriptive with the SOAP note, which is really the standard, I think, other than in Medicare, where they might, you know, I think we'd want to clarify somewhere in here if we were to model something after an established patient visit. that, PART as an acronym might also be an acceptable way to chart a follow-up is the established patient visit.
I concur. One of my other questions that I had as I review this is that what about, this always assumes that, these record keeping aspects always assuming that, somebody has a complaint whenever they come in. And I have a number of patients that don't come in with any complaint, as I have kind of more of a lot of my practice is a wellness practice. So people are coming in because they, much like, dental patients that brush their teeth and floss, they don't brush and floss because they have pain in their mouth. They do it because they're, want to maintain, they want to keep their body, to not have pain, not have cavities occur. So how do we address in our notes the wellness type practice where people are coming in without necessarily a chief complaint, just wanting to come in for, quote, the tune-up or the checkup?
My suggestion would be that, you could still use soap, and, you would just state as such. You would still use, and they would just maybe as essentially the subjective, of course, would be, whether or not they had one at all or anything going on, or kind of a brief between visit, no new injury, trauma, accident, that type of note. And then, the objectives would be if you're palpating or if you're doing like, finding subluxation, however you document that. But then also, we tend to think of objective findings as always the negative or, well, positive orthopedic tests that indicate an issue, and things like that.
Right.
But there may be something to put in there that, perhaps gait was normal, and, that there was no abnormalities detected. I mean, I think that's, in that scenario, that's just as valuable to document as, anything else.
Okay. I like that idea. Yeah. Would it be, you think it would be required for us to delineate out, if because there's a lot of people out there that identify themselves as wellness practices. I mean, obviously I have people that come in that have chief complaints, initial visits, and then, then they become more of a wellness patient after that, and addressing, their balance or eye movements from a neurological standpoint, gait, and then move on from there and do, make recommendations neurologically, not necessarily always an adjustment, nutritional component aspects. You don't think it's, or your thoughts on whether we need to delineate that out in this as a direction to staff to have that as a component, or is that satisfactory? What you just commented on, Dr. Paris?
Well, I think in those scenarios where you're providing treatment for something that may be somewhat asymptomatic, but maybe perhaps performance improvement, or ADL improvement, things like that. I think we see a lot of that here in the environment that I work in, where we have some, not necessarily, maybe it's a desire to do something better, and there's really not necessarily a functional deficit or a pain complaint. So I think that happens, but I think you can use the SOAP note to capture that. It's just we tend to think of the S in the SOAP as being, that there's actually a chief complaint, and that there's actually, an issue. So I think it just transitions to a different looking note. And obviously what you mentioned, those could go under objective findings too, if you're doing any, testing or physical function measures, et cetera. And I think the rest just kind of flows along. I think it's just as important that we remind, it's when you identify a negative test or a normal test, even if it's something you just observe, it's important to document that too for, the record. So yeah, so I mean, I think you can still use SOAP in the same manner.
Excellent.
Yeah.
Yeah, I liked some of the Colorado regulations as well. Thought it was laid out pretty well. My question is to the two of you who are more familiar with these, is this, I wasn't sure if some of these requirements seemed more burdensome on providers than what we currently have, and whether that's, too burdensome, I guess, is the question. Particularly in regards to not just the SOAP notes, but the retention of records and records after, you move your practice or things like that.
Well, that's never been an issue for us. I've been at the same office for 20 something years. So we have a lot of records, and they get, and really for us, the digitization of records has now become so pervasive that we actually have drastically reduced our storage, if you will, because it's all in the cloud now, and it makes it so much easier. And so just when something hits 5 years and they haven't been in, then we just delete it, and it makes more room in our cloud storage aspects, which has been really, really helpful. So, I mean, in reviewing these scenarios from these different states, I found them to be, to not to be burdensome at all. They're basically already what we're doing in our practice. But I can't speak to what that would be for someone who's, going to be the caretaker of records for 5 years. If somebody, has boxes and boxes and boxes and boxes of stuff, that might be a, and a whole nother topic. They would obviously have the option to put those records that, pay someone to have those records copied and put into the cloud like we've done over time.
Yeah, my response would be that I think the Colorado example really delineates kind of standard of practice, and I think most are doing that, or we have expectations that they're doing. That's the way you're taught, and it really aligns with what something that came up during a CE committee meeting, which is that it aligns with the CPT and E&M coding and the basic framework and requirements that are held within that. So if you're coding for those E&M codes and you're doing 9920, there's no 201 anymore, but 202, 203, 204. It's very, that really defines the aspects of that coding. And I think most, as regard to retention requirements, I really think most have transitioned to, at least partially transitioned to, electronic record keeping, et cetera. And in the past, maybe more of a burden to think that you're going to have 10 more boxes in your office, or you need another row of files, the file row. But I don't think we really see that anymore. I'm sure there's some legacy out there with that, but so I wouldn't, in my view, I wouldn't consider it that much of a burden to have a little bit of a higher retention time frame, et cetera.
Thank you. No, that's helpful. That makes me a lot more comfortable with it.
Okay. Any other comments or questions of Ms. Pitto? Ms. Pitto, did you have anything to add based after hearing our discussion, or?
I do not. Kristen, do you?
No, this was clear. As far as what the staff request on this item is, just given that it's so technical in nature and we don't want to draft something that's not consistent with the standard of care, or something that would be expected or maybe conflicts with existing requirements. We have two requests basically at this meeting. Is so there was the prior proposal in 2015 to address dealing with patient records upon the closure of a practice. The staff recommendation is to merge that concept with this one to update the content of the records. And then two, if the committee wouldn't mind appointing one member, no offense to Mr. Sweet, but preferably one of the licensee members to assist staff in getting the technical requirements right on the language.
I'm sure he's okay with that. I don't want to be appointed to something that has to do with the law, so I could. I think that's great. All right. Well, if there's no other comments, we probably should open it for public comment before we make a motion. Or Ms. Knight, should we make a motion and then open it up to see if or open for public comment? What do you suggest?
You can do either, but best practice is always to have public comment after a motion so that the public knows exactly what you will be voting on. But you can do it before, you can make a motion, and then, you can do it afterwards as well. It's up to you.
All right, well then I will entertain any motions from the committee relative to what staff is requesting of us today.
I guess would the motion just be for either Dr. Paris or someone to be assigned to this committee to work on this? Is that the requested motion? Something along those lines?
I think they're looking for us to give them direction, like to look at adopting language that is consistent with, say, like the Colorado guidelines. Sounds like, I'm pretty comfortable with the Colorado guidelines as kind of as a backbone. Is that kind of what you're looking for, Kristen? Is rather than reinventing the wheel here, we have a good kind of a profile that can be built on, and then eventually brought before the full board to vote, as well as in the preparation for that, to have one of the board members to act as a kind of a assistant to the staff in that process?
Correct. Yeah. So what we're looking for from the committee ideally would be a motion to direct staff to basically work on proposed language to amend Section 318 to update the patient record keeping requirements, and then also merge the prior proposal to address situations to address basically the handling of records after the death or incapacity of a chiropractor or relocation of a practice into that package. And then, ideally, if we could appoint one licensee member to the board to act as kind of a technical resource in the drafting of that language. And then staff would bring it back to this committee for review and discussion at a future meeting.
Did you get that, Ms. Knight?
I sure did.
You want to attach your name to that, Mr. Sweet?
I'll make a motion in accordance with what Ms. Walker outlined.
And David, do you want to take that, or do we want to assign Dr. Daniels to do that, since she's not here to defend herself? Okay.
I would be happy to assist with that, and I wasn't. I would have to hear the whole motion again, but if the motion has to include the aspect of also not just incorporating the Colorado example and making sure we include the part for the follow-up or the established patient visit, but also I would suggest that we look at and utilize CMS. They have a services guide, an E&M, an Evaluation and Management Services Guide, that was updated in January of this year, that I think would be a really useful resource in identifying or at least discussing some further components that we may or may not want to include beyond what Colorado's example demonstrates.
Excellent. Sounds like you're the man for the job. So I think you volunteered, Mr. Sweet, to be the name in the motion. That's what I heard.
I don't know that I can repeat it properly, so hopefully we've got it. Is that fair?
Ms. Knight, do you have that motion that Kristen kind of outlined that Mr. Sweet is putting forward?
I think I have it in bits and pieces. I'm not sure if Ms. Walker wants to repeat it, but we know we have it recorded also for our minutes. And then we can just insert Dr. Paris's name into that motion if Mr. Sweet agrees to that amendment.
So my understanding, the gist of it, actually, Kristen, why don't you just kind of clarify and let Ms. Knight hear what you said again, knowing now that Dr. Paris will be the liaison.
Sure. I think I can state it a little more broadly so that it's hopefully just more clear on the direction, but the motion would be for the committee to direct staff to work on, to prepare proposed language to amend section 318 to address current record keeping requirements and situations or the retention of records following the death of a licensee or the sale of a practice, with Dr. Paris identified as the technical consultant to assist staff, and then bring it back to the committee at a future meeting for review and discussion.
That sounds good to me.
I'll second that.
Open it up for public comment now.
Yeah, I just wanted to hear if Sabina needed anything else.
Oh, sorry, I was not unmuting myself. I agree. I like the pared down version of the motion, hitting the highlights here with the section and the subject matter for the updates with our Colorado as our reference. And we can go ahead with public comment.
Excellent, thank you. Okay, Ann, would you open it up for public comment, please? Thank you.
Certainly. We've opened up the WebEx Q&A feature to facilitate public comment. You can look for the question mark, typically in the lower right corner of your WebEx screen. And then in the text box, type the word comment and click send. The other option for commenting is to raise your hand. You can do that by clicking on the hand icon in the WebEx screen, or if you are a call-in user, you can press *3 to raise your hand. Each commenter will have 3 minutes to speak. And I see no requests for public comment. Shall I close that screen?
Yes, thank you.
You're welcome.
Any other comments or questions before we move to the vote? Okay, having no comments or questions, Dr. Paris, will you call the vote?
Yes. Dr. Lawrence Adams.
Yes.
Mr. Raphael Sweet.
Yes.
And Dr. David Paris is a yes.
Thank you. We'll move on to agenda item number 5, review, discussion, and possible recommendations regarding proposed changes to the board's disciplinary guidelines and model disciplinary orders and implementation of the uniform standards for substance abusing licensees. And Ms. Walker, we'll turn the time to you to clarify this item.
Sure, thank you. Let me see here. Let me just navigate here to my notes. So for the past, just a little bit of background information on this is the disciplinary guidelines and uniform standards have been on the pending regulation workload for quite a while now. The board's been working more recently on updates to the disciplinary guidelines themselves. As far as today's discussion, I'm going to start with the uniform standards and then move into the guidelines. And just to provide some context on the uniform standards, Business and Professions Code Section 315 established the Substance Abuse Coordination Committee within the Department of Consumer Affairs, which was comprised of executive officers of the Healing Arts Boards and chaired by the DCA director. This law required the committee to formulate uniform and specific standards that each Healing Arts Board shall use in dealing with substance abusing licensees in 16 different areas. Those 16 standards developed by that committee are contained in the meeting materials under agenda item, or under attachment number 2 for this agenda item. While those uniform standards are mandatory, the healing arts boards have the authority to determine the appropriate trigger for the application of those standards based on 3 options. The first option is a presumption and that the licensee is a substance abusing licensee unless that presumption is rebutted by the licensee. The second option is conducting a clinical diagnostic evaluation of the licensee to rule out. And the third option is finding evidence establishing that the licensee is a substance abusing licensee after providing notice and conducting a hearing. At the July 17, 2014 board meeting, the board voted to approve this third option for applying the uniform standards. So at this point, the package itself, we've got the direction from prior board members on the trigger for the uniform standards, and where we need to go from here is update the disciplinary guidelines document itself so that we can push this package forward. Staff has been working on the updates to the guidelines. We held kind of a roundtable discussion, if you will, of the enforcement staff to kind of talk through the standard and optional terms of condition and conditions of probation that we felt would strengthen the effectiveness of the probation program. So as far as today's discussion, looking at attachment 1 within the meeting materials, and if moderator, if you wouldn't mind displaying those materials for us.
Is there a specific, oh, my apologies, one moment. One moment while I load the materials.
Sure, no problem. I'll continue with kind of some background information as we get there. So for purposes of today's discussion, looking at the disciplinary guidelines themselves, it's a document that's incorporated by reference into the board's regulations that the committee's been working on updates to, and that we'd like to try to kind of finalize those, not at today's meeting, but within the next few meetings. That document contains a lot of background information on the board's disciplinary process. It then also includes each of the violations of law with specified parameters for the minimum and maximum recommended penalties for violations of those laws. Then it proceeds into proposed language to use for model disciplinary orders so that when an administrative law judge is drafting up a disciplinary decision, they can take those orders and just put them directly into our disciplinary decisions. And then from there, we get the menu of options for probation conditions. So to hopefully simplify the discussion this afternoon, within the meeting packet, that attachment 1 is actually the language of the standard and optional terms of condition removed from the rest of the document so that we can just look at this language. And it's purely for discussion purposes at this point. It's not final, it's very much in a draft phase, but we just wanted to try to represent what we kind of felt would be some good changes to make within the document itself. As far as background information, the standard terms, as the name implies, those are included in all probation orders issued by the board. And then the optional terms and conditions of probation provide you with the menu of additional options that can be imposed just depending on the circumstances of a specific case. And then as far as where we go from here is we just want to discuss these terms and get some feedback from the committee before we move on to then trying to apply different terms to the different violations within the laws and regulations we have. So briefly, I'm just going to touch on just a few of the major ones, and then I'm going to return it back to the committee for discussion on the language and just the concepts behind those language. I wanted to point out on the first one for obey all laws in about the middle of the second paragraph, you can see that we've struck the language talking about getting fingerprints. That's in no way intended to actually remove the requirement. It's just redundant and unnecessary because any applicant or licensee that gets to the point of being put on probation has already been fingerprinted by the board. So we don't have any circumstances where we need to collect prints. So we're proposing to remove that. A lot of this language here is just intended for clarification purposes and to strengthen what we have. As far as a new changes worth noting for the committee is if the moderator could go one more page forward, that paragraph number 5 there, maintain a current and active license. Staff is recommending that the committee consider mandating that licensees on probation must maintain an active and current license with the board at all times. And then we've included something there for circumstances where the license has already is currently expired, mandating that they file an application to renew or restore that license within 30 days. And just a little bit further down, thank you, Anne. The continuing education paragraph that you see has been removed there. It's kind of redundant and unnecessary, so we try to capture that instead with the new language of maintaining the license and complying with the board's annual CE requirements. The other language doesn't have much teeth in it, and we already have a regulation that requires that you provide evidence of CE if requested, so we just felt it was unnecessary to include it in the guidelines. And going a little bit further down, we have a new proposed condition number 7 that we'd like to explore, and that's on probation monitoring costs. Currently, on our enforcement program, we have the ability to recover the costs of our investigation through the probationary period, but just given our budget situation and the fact that we spend quite a bit of money on disciplinary actions, we want to, at the staff level, explore potentially having a cost associated with the probation monitoring activity itself. Kind of in theory, what we're thinking is that we would bill the direct cost or a portion of the direct cost of the staff time for monitoring the licensee. So those that are in compliance with probation would likely have minimal costs, whereas the ones that are frequently having issues and resulting in more contact by the probation monitor would incur higher costs associated with that effort. Also probably notable to the committee, the item number 8, which is tolling of probation, which we can actually go to the next page. This one, so another issue that we've seen with probationers is that the current guidelines don't require any minimum number of hours for you to be considered in practice. And the purpose of the probation program is that licensees are practicing and rehabilitating and getting back to where they can safely serve the public without monitoring. So for this, there's language in there proposing that a minimum number of hours of practice of 24 hours per week while they're on probation, or otherwise it would trigger tolling. And then just also kind of cleaning up and clarifying what tolling is. Some of that prior language was kind of difficult for, I think, licensees to understand. So we looked at some of the other boards and tried to kind of model it after some language that we thought was a little bit more clear. Also notable within this is just clearly laying out that non-practice is either not engaging in the practice of chiropractic, failing to meet those minimum number of hours, or anytime the license is expired or inactive, in forfeiture status, anything to that effect. The new number 10, we included a prohibition from serving as a continuing education instructor. We just throwing that one out for ideas and discussion by the committee, but we felt that anyone that's on probation by the board probably shouldn't be authorized to serve as an instructor of continuing education courses during that probationary period. So we found this is kind of a mechanism we could use to enforce that requirement. And let's see, the next page, please, moderator. Right there. So we've tried to kind of increase our access to information and tracking of the probationers. So for the the renumbered 12, notification of contact information and employment status, in addition to just simply notifying us if they change employment, we've tried to strengthen that they need to give us their contact information, where they're practicing, residence, email address, telephone number, and employment status at all times while on probation, and setting reasonable timeframes for them to provide that information to their probation monitor. Let's see. Skip one more page, please. Number 15 is new. So the notification of probation status to patients, this language was included in there to reflect the requirement, the patient notification requirement of Business and Professions Code Section 1007. And it includes, it's basically reflects the language as effective January 1st, because this was recently amended through our sunset bill. So we only have the exemptions in there that will be in effect after the beginning of the year. That's it for the standard terms. I can run through just a few of the optional terms. I think I'm just going to note for most of them, it was just merely trying to strengthen language, or in many cases, just clarify some of our different language that we have. I think of note for the optional conditions, we added one for Part 4 of the national examination in cases where there's questions of a licensee's competence and you want them to take a practical examination. We'll include language for that, including language for the ethics and boundaries examination that's often ordered in our disciplinary decisions. Probably the biggest item of the optional conditions for discussion by the committee today has to do with monitoring of practice. So in the current guidelines, there's monitoring, which really kind of encapsulates practice monitoring. And then there's a term right after that for auditing of billing practices by a certified public accountant. In many cases, staff, and I believe the board may even agree, but we don't believe that a CPA is appropriate for auditing billing practices within that language, because billing practices and record keeping are so intertwined that it's not, in our opinion, it's not really possible for a CPA to meet that level of review when they can't review the records and ensure that appropriate coding was made, and then it reflects in the billing. So what we've kind of taken a stab at there is just collectively having monitored practice and with different levels. So where it could be supervision on a full-time basis, substantial, moderate, partial, all the way down to just a records review. And then depending on the circumstances of the violations that led to probation, that's where billing monitoring would be covered. If the licensee had billing issues, then their monitor would be monitoring to those issues. So it's kind of the intent there, but we really would like the committee's kind of feedback on that proposal of basically kind of eliminating the standalone billing monitor, instead incorporating that as part of practice monitoring. Let's see here. We have two more, I think, of note. I know there's quite a few of them here.
Can I just hold you right there? So are you suggesting that it be like a chiropractor that can understand the note taking as well as the other aspects?
That's the staff proposal for the discussion today. Is instead of having having a CPA doing billing monitoring, instead identifying appropriately qualified doctor of chiropractic to serve as the monitor, because then you're not only looking at the billing itself, but you're also looking at the records to make sure that the records appropriately match up with the billing. Yeah. Let's see here. And then the next one of note, so for the third-party chaperone that's put into place, we've took a look at some of the other boards' language, and we really wanted to strengthen that because it truly goes beyond just simply having another person that's on the premises. So that's where we've tried to really specify that they need to be in the exam or treatment room at all times. As far as the information that we're requesting by the probationer themselves, is the current language just simply says they give us their name. For approval, they just provide us with a name. Well, we would like contact information and a photograph of the person, because there are instances where we do our own independent inspection to verify compliance. It'd be helpful if we could accurately identify that person that was designated as the chaperone, and then also have direct contact information so that if we have any questions about a licensee's compliance, we can ask that person, and we don't have to rely on the probationer that we're monitoring kind of serving as the intermediary. Then there's some requirements about, let me see here. The other one of note is adding that third-party chaperone should be signing and dating each record at the time that the chaperone is present, and maintaining a log of patients for whom that chaperone was required, and making that log separate and available to the board upon request, and retained for the entire term of probation. So a lot of this was modeled after language that we saw with the medical board, and we thought it was appropriate because in these cases, when we've ordered a chaperone, we don't really have effective checks in place to ensure that it's being done, because we don't have access to the information of the people that were subject to that requirement.
I had a quick question about that. What in the case of I mean, is it always just one person, or is it somebody can it be the doctor's staff? And can you designate like 2 or 3 people to be chaperones in the event that one person, because you got to, you think of a doctor's got a full schedule of patients, and a chaperone is an outside third party that cancels on them, and so they can't see their patients. What do they do, right? So is there backups, and can it be a CA in their office that then is designated and can do that for them?
It can, yeah. In many cases, the chaperone's usually identified as support staff or someone within the office, and we do allow for them to identify more than one person, and that's pretty typical. Is if they have 2 or 3 different ones, that would be fine, and that kind of goes to the point of maintaining the log and signing the records. Is when we get complaints that there wasn't a chaperone present, it's really important that record accurately reflect who that chaperone was, so that if we interview them, they can substantiate that actually occurred.
Excellent.
And the last one to note here, and this is rough, but I just put it in here so that to kind of facilitate the discussion, but a new optional term on limitation on practice locations. With kind of the intent behind this one is kind of when it may be necessary, being able to limit a probationer to only practicing at really a brick and mortar location that's on file with the board, and prohibiting them from being able to practice in kind of a mobile setting, or certainly at a patient's business or residence. It's just depending on the circumstances of certain cases, it's not appropriate to be allowing licensees to go into patients' homes, or at least that's the staff kind of recommendation on that. So we've kind of put something together just to kind of facilitate the discussion today on, get the committee's feedback on that. But we were thinking there could be circumstances where it'd be appropriate to say, you're prohibited from going to a patient's home, and instead you must be at one of the practice locations currently on file with the board. So I know there's a lot there to digest. I would like to turn it back to the committee for any just kind of feedback on any of these concepts. Like I said, the language itself is very much just for discussion purposes. This is nothing that we're planning to present formally as the final language. We're just really interested in the committee's feedback on the concepts behind it.
So one quick question before we go back or forth is on 21, when you said limitation on practice locations, how would that be in respect to vacation relief doctors? Would they have to notify the board ahead of time that they are going into a practice for vacation relief? Is you're looking at something like that as a mobile chiropractor?
For the probationers, yeah. So this would be an optional term, but the idea behind it would be that it would actually kind of prohibit that practice, because they would only be permitted to practice at a location that's their primary address of record with the board, or a location where they have a satellite office or a corporate certificate. So for them to practice on a fill-in basis, they would only be able to do that if they had a satellite. And the reason we've put that here as an optional one is in many cases, this isn't necessary, but there could be some, particularly if we have sexual misconduct type complaints and we have concerns with where they're practicing, that we want to make sure we know exactly where they are. So that's why we've put that as an option for the board.
So this is specifically referring to a doctor on probation. So really, a doctor on probation would not be really allowed to be a fill-in doctor for somebody else, because he would or she would be required to have somebody chaperoning them, or in the case of sexual misconduct. But any probationary chiropractor, regardless of the circumstances, is going to need, it probably wouldn't be able to be a relief doctor. Is that pretty clear? Does that make sense?
Only if this condition is imposed. So we've put it under optional. So if it's not included in the disciplinary order, then they could still be a substitute. They could practice in a mobile setting or move around. It's just really, it's kind of adding to our menu of options of what we could do if we see fit and it's appropriate for that case. So it's not included. So within the meeting materials, there's the first numbers that are mandatory, like for things like we're going to require you've maintained a valid and current license. That's under standard, so it would apply to anyone that's on probation, whereas these optional terms are just added when appropriate.
Thank you for the clarification. Okay, we'll open it up to the committee for any comments or suggestions or motions, if you're so inclined.
I mean, for me, I had a number of questions, but Ms. Walker did a great job of addressing some of those things. So it sounds like a lot of these, I was kind of wondering just generally what we're basing some of these additions or changes on. And it sounds like you're drawing a lot from the medical board. Is that right?
We're drawing them from other healing arts boards that have recently updated their guidelines. The intention behind a lot of them is to clarify requirements where you see more minor changes. And then also some of the experiences are drawing off of kind of challenges that we faced in the past in our enforcement program and kind of opportunities where we saw that we could further strengthen what we have available to us.
Yeah, on number 7 for the on the standard terms, the probation monitoring costs, I know that I'm sure that it varies, but do we have a sense for how much additional cost that might incur for someone who's on probation? Just as like a general estimate, is that going to be hundreds of dollars? Is it going to be thousands?
Our initial estimate on that would be, hundreds per quarter. So maybe $1,000 to $2,000 a year. It would increase substantially if we had someone that was repeatedly, violating probation and we were having to increase our contact. But just based on like the direct staff hours spent on verifying compliance with these terms, reviewing the quarterly reports, it's very minimal, and we're estimating it to just be in the hundreds of dollars every quarter.
Okay. And would that make in terms of all the probationers that we have, would that make a significant impact for the board's budget?
Collectively, it would assist in the budget. It's not going to make a substantial impact in the grand scheme of the full budget amount, but it is certainly, it is going to have an effect, and it would benefit the board financially.
Can I follow up to that real quick, Mr. Sweet?
Of course, yeah, please jump in.
So Kristen, is the idea, so let's say you've got somebody who's on probation for 5 years. They start off their probation, they're paying for the monitoring on a quarterly basis, costing them hundreds of dollars. But let's say they start to, they're showing that they're being compliant, they're doing a good job. Can there be a reduction in that monitoring so that they're, for good behavior, I guess, in a sense, where it would be like every other quarter, so their impact financially could be lessened as they show good behavior or show good compliance?
So at this point, it's a discussion that we've thrown out there as an idea for the committee. We can certainly bring back a lot more concrete ideas behind actual costs and impact if it's something that the committee would like to see pursued as part of these guidelines. Or otherwise, if it's not something that wants to be included, we could remove it. We are estimating very minimal costs at this point. We have a 1 full-time probation monitor. We have about 65 probationers, and that probation monitor doesn't spend the entire day even monitoring those probation. So really, it's we're talking in the hundreds of dollars per quarter or less per probationer. There are instances where if we're billing directly on the amount of time that's spent on somebody, if they're consistently not meeting requirements for their probation, they're consistently needing contacts, we're having to pull them into meetings, we're having to go out and do site inspections, they're going to have, if we went on that kind of rule, they would have a higher bill than the person that's doing everything correctly, filing their reports on time, abiding by the rules. They'd have very minimal costs. And I mean, another way to structure it too could just be a flat fee per quarter of a couple $100s for everyone on probation. It doesn't have to be billed as direct staff time. It could just be a flat fee. There's plenty of different options to explore. We put that in there to kind of facilitate the discussion and kind of get the committee's feedback on whether to even move forward with that or not.
I personally, I like the idea that, because it's a way to, remunerate, the board's time being spent on, and obviously we can structure it so that, people that are, I would recommend that, that staff in that particular line item, put some language in there that says, as something along the lines that as the probationers, comply and, that fee, that if we do a flat fee or something, would be reduced, for, for good monitoring or good behavior. And then obviously that would, help offset the people that are becoming more of a pain in your side, requiring more attention, or having, people that actually have to leave the office to go do a site visit because they're not complying. Seems like it'd be helpful to offset those costs.
Yeah,
I'm done. Go ahead, Mr. Smith.
Oh, sorry. No, I agree with that, with what Dr. Adams was saying. And the primary reason that I was asking is, one, to just kind of understand, for someone that, in the future that we do put on probation, how much are we burdening them, or how much are we asking them to pay if this is going to be something that's like an extra $10,000 over a few years versus a few $100s. But I like the way you laid it out, which is that if someone is complying, it's going to be more of a minimal cost than someone who's, like Dr. Adams pointed out, someone that's a little bit more troublesome, I suppose. So I don't have a problem with that. I was just kind of more trying to gauge how much of an imposition this was.
Right. And it's going to depend, like we said, on the amount. I think it sounds like there's support there for billing kind of the direct cost. And I think looking at just the programmatic costs in general, that also helps shift the burden of paying for the probation monitoring activities from the licensee population themselves, and kind of shifting it on the probationers whose conduct we're actually monitoring. Since it sounds like there's support, we'll get a little bit more concrete details on that and report back when we bring this item back to the committee.
Any other comments or questions?
I have a few, in the interest of time, and if it pleases the chair, I'll just kind of run through them. I just had a few clarifications, maybe as we go through. A lot of them were answered.
Sure.
So I'm wondering on number 9, the preceptorships or supervision of interns. And I remember as a new licensee that there was also a postceptorship, a program where you were graduated, you were no longer a student, but you were unlicensed, and so you could apply to work under another licensee's license and be monitored by him. Do we still do those?
That's not formally addressed at all in the board's regulations. We just have the preceptor program, and then I know that some of the schools kind of put on a postceptorship under a preceptor. That's kind of an item that the licensing committee, I think, needs to do a little bit more work on, is regulations surrounding that preceptor program. But this language itself would capture anyone that's a postceptor in a preceptor program.
Okay. My suggestion, if we were doing that actively or using that language, my suggestion was going to be to add it. And then under 10, I'm wondering if that language could reflect and maybe have an attestation when that they have not been, they're not on probation from any state, that they don't have a chiropractic license on probation from any state. And bear with me. And under in the optional terms, and 7 and there's an option 1 and an option 2. And I was wondering in option 2, and if that was going to be more specific to naming the not just the CCLE, but maybe adding the spec or part 4 or some of the other examinations that we might want to include there, or is that intentionally just CCLE?
Nope, that was just, so in the prior language already had those options. We can include similar options for the other examination components for consistency.
Yeah, and then I was wondering too, then moving to 8 from there, that perhaps we consider, I mean, I would imagine it's not as likely to see somebody replacing the functions of the MBCE as a whole, but perhaps maybe some of the special examinations that are offered, you know, with the SPAC and the EBAS functions, and we named them specifically in 10. And so I'm wondering if maybe we should have broader language that would allow, you know, other testing services or equivalent as approved by the board, something like that. I think we did that with some language in regards to CCE, some regulations previously where we.
Yeah, we can certainly make those updates. Is that for EBAS or also, I mean, the NBCE exam and spec are pretty specific. Do you want to make those broader or just the EBAS?
No, I think it's okay that we name them, but I think in, like, I'll just use number 10 as the example. I was using option 2 to consider spec in part 4 in number 7, but now I'm down to kind of 8 and 10. Both name specific evaluations. They name the EBAS and the spec, I think, or did they just name EBAS? Yeah. And so I'm wondering if maybe we don't want to pin ourselves in by having that, you know, we could name that, but then give ourselves the opportunity to utilize or an equivalent, you know, examination as approved by the board.
Okay.
I'm just future thinking that we may have another option. And the auditing, I completely agree. I can't imagine. I liked all the language here too, I want to say, so I'm supportive. I can't imagine that a CPA has any idea what chiropractic billing and coding should look like. So it's a good change. And I was wondering if in the chaperone section, I didn't actually, well, let me back up. In 18, before I get there, in 18 under community service, I'm wondering if we might include language there that that eliminates their ability to do their community service with anybody that they have a financial, personal, or business relationship with.
Yeah, that would be a good change. We'll incorporate that.
And then under in the chaperone in under 20, I'm wondering if it seems like the chaperone has kind of acknowledged the accusation. I was thinking we might want to strengthen that they understand their role, but I think that's sufficient. So let me just get off of that. And that was it. Thank you. I have no further questions.
Excellent comments. Anything else, Mr. Sweet?
No, I don't think I have anything else on this one.
Okay. Well, I think we should put forth a motion, and perhaps like we did on the last one, Kristen, if you can kind of outline what you're looking for, what a motion would look like, and then move forward just like we did on the last one, and make sure that that's satisfactory to Ms. Knight, and then move forward with public comment.
this is Sabina. I don't know if a motion's necessarily needed at this point. I'll let Ms. Walker chime in as well, but it sounds like they're just gathering the information from this discussion and they're going to go back and rework some of the language and then bring it back.
That's correct. Yeah, we don't need a motion from the committee. We appreciate all the feedback, and we're going to incorporate that into more updated language. And kind of the path forward beyond here is, since there was pretty much concurrence on this menu of options, we're going to clean up some of this language, bring it back, and then also the next step will be diving into the different laws and regulations themselves and setting the parameters for violations of those laws. So that's kind of what's to come on this, but we've got what we need now. Thank you.
Excellent. Well, I think the language there and what you've done is excellent. I mean, this is really good. I think we're moving things forward really well. So thanks for your leadership on that, and to your staff as well. Those of you that are attending, thank you for your hard work. Okay, with that, let's open it to public comment.
And this is your moderator, and we've opened up WebEx's Q&A feature to facilitate public comment. If you'd like to make a comment on the topic, you can look for the question mark icon in the lower right corner of your WebEx screen, or behind the 3-dot other options if you're on a mobile device. Type comment in the text box and click send. The other option is to raise your hand by clicking on the hand icon on your WebEx screen, or if you are a call-in user, you can press *3 to raise your hand. So we do have a couple of requests for comment. I will start with Dr. V. I'm going to send you a request to unmute your microphone, and you will have 3 minutes to speak. And you're unmuted.
Okay, thank you. I just had a question. So if the doctor is going to be charged hundreds or thousands of dollars for his misconduct, is there something in the rules and regulations that can be added to have them be required to get some counseling or some help? Because there are a lot of programs out there that can help them. Just because if they make, one mistake, after listening to, I think it was in February, we had a board meeting and a doctor was under disciplinary. He had one encounter with a patient and it was just a one event mistake. So instead of punishing the doctors with all these fines or, monthly charges, can you actually require them to seek counseling, to get, an accountability partner, something that can help them kind of figure out what led to this event? There could have been childhood trauma or abuse. So I want to be able to not just punish the doctors, because there are those out there that are doing seminars and they're under, disciplinary action, and they're good teachers. So I don't want them to lose their license or to be revoked or, and to be financially burdened through all these costs just because they made, a mistake for one event. So that was my question, is if you can add that into the regulation that they are required to seek help, counsel, and to figure out, what led to that and how can they fix that and to be completely restored. And that's all I wanted to ask. Thank you.
Thank you for your comment.
And our next request.
Oh.
Did you have something?
Sorry, that was Sabina. This is Sabina. I was gonna offer to address that comment, but I can wait till after the next comment.
Thank you.
All right. Our next request for comment comes from someone logged into WebEx as Chris Green. And Chris, I see that you've got my request to unmute. You may start.
Okay, great. Hi, this is Chris Green. And I've served as a practice, hold on, I got to turn off my phone, it's echoing. All right, I've served as a practice monitor for several states, for Colorado and Wyoming. Getting clarification to the monitoring program would be really beneficial. One of the challenges for a monitor is how to actually structure a report that goes to the board. And then also clarifying what it is that the monitor is actually reviewing. I was reading through the language that's in the draft here, and it could be tightened up. The more it is, the better. And the reason why, so there was a question from Mr. Sweet about cost. The cost can get quite significant for the respondent. There are monitoring businesses out there. Affiliated Monitors is one of them. And so it's just, there's a big staff and everything involved in that. So the more, the more people you get involved, the more it can get, pricey, meaning like $1,000 to $2,000 per quarter as a report's generated. Costs can be decreased by the greater degree of specificity as to what it is that the monitor is actually doing. If they're looking at patient records, if they're going on site, if they're observing the respondent with patients, or if it's just a paper review. So in the way that Rule 22, that's the chiropractic documentation requirements, in the way that that gives greater specificity, it makes it easier for everybody, chiropractor and reviewer / expert on both sides, because we know what we're talking about. That same level of specificity would be very beneficial for the monitoring program. And then that's it for monitoring. Regarding Chaperone, there are some training programs that are out there that are pretty, like it's a few hours long. It's not some big long thing. But there are training programs out there for chaperones. The big question, like I heard it asked, could a staff member serve? The answer is yes, but if the purpose of the chaperone is to be observing the doctor-patient interaction, where this has become a question like in the medical board, is if you had a scribe, chiropractors don't generally have scribes, but if you had a scribe and they're doing documentation, writing a record, well, they can't be fully focused on the patient chiropractor in our case, the patient chiropractor interaction. So you do have to really define what it is that the expectation of the chaperone is and what they're doing when they go in there. Can a staff member serve? Yes, but they can't be dual purposed, nor can they leave the room either. Another thing that's important to answer is the question, could a family member serve? And the answer is no, because of course they're biased. So I think that there's a lot of resource to be gained from the medical board. And then there's also training courses to train somebody to be a chaperone. So hopefully that helps.
And our next request for comment is from Dr. V. And Dr. V, I will send you a request to unmute your microphone.
Yes, my other question was if the doctor is actually under disciplinary action and they are holding seminars, can they continue to do that even if they're not the lecturer and they're not presenting, but they have someone else doing that? And will we be able to get credit for it if we take their seminar? And that was my question. Thank you.
Thank you.
And I see no further requests for public comment at this time. Shall I close the Q&A?
Yes, thank you.
You're welcome.
So Sabina, I'll give you time. You said you were going to respond to the first question from identify, I guess, as Dr. V.
Yes, I just wanted to direct Dr. V to the materials where in the optional terms, there's items called psychotherapy, there's a psychiatric psychological evaluation or examination. I think maybe this board uses the word examination. So there are all those type of rehabilitative type of terms are in the optional terms. So should the specific facts to a case, lend themselves to something like that, that absolutely can be included in someone's probation order. So I wanted to let you know that those are there and they are possibilities for probationers.
Thank you.
I would add one more potential suggestion to that comment, and that is that the nursing board has a program for substance abusing licensees. Ms. Walker, you could maybe correct me or clarify it further. I'm not as familiar, but I believe it's a voluntary program, and they enter of their own volition. And I believe it's made available prior to any violation or discipline being imposed. And I think it's along the lines of what was mentioned, in that this is an opportunity to get help before you get forced to get help. And so my suggestion would be, I don't know if that's a shared program amongst DCA and the licensing boards, or if that's something that we could inquire about making that available to our licensees.
Sure. Dr. Paris, I believe you're referring to the Board of Registered Nursing, and some of the other healing arts programs have diversion programs. This board currently does not, but if it's something the committee is interested in, we can report back with additional information on that topic.
I'll save it for new business.
Hi. Yeah, please bring that back around, because I think that'd be valuable information for us to contemplate and discuss. Okay, any other comments or questions? Okay.
I actually have one more just question. I apologize. Under the uniform standards in number 5, which is
You're located in Reno?
that if a board requires a licensee to participate in group support meetings, the following shall apply. And then it gives a group meeting facilitator qualifications and requirements. And I'm wondering if that restricts the anonymity of a program like AA.
Potentially. So for the uniform standards themselves is a little, they're much more stringent than kind of what we see in the optional conditions of probation, because in those cases, that's when we've substantiated that they are in fact a substance abusing licensee, and it triggers much more stringent requirements. We have a lot more flexibility in our optional conditions of probation in cases where there's been a violation that we want to impose certain terms, but it doesn't meet the level of being deemed a substance abusing licensee within this context. So yeah, I hear your concern on that.
So this would be like second level group meetings. Like maybe they've already done AA. Now we want something more stringent or more formal. These
terms would be imposed in a case where we've determined, we've gathered all the evidence, we've gone forward with a hearing, and we've put them on notice that we believe that they have a substance abuse problem, and we substantiate that through a finding of fact decision. If we meet that burden, all these additional terms would apply.
Thank you.
Any other final comments or additions before we move to item 6? Okay. All right. Well, I think we've got a good backdrop there to go forward with. Okay. Item number 6, review, discussion, and possible recommendations regarding proposed regulations for disciplinary decisions involving sexual contact with a patient and required actions against registered sex offenders. And Tammy Pitto will explain more to us. Ms. Pitto?
Yes, thank you, Dr. Adams. So at the August 29th, 2016 board meeting, as part of the Comprehensive Consumer Protection Enforcement Initiative regulatory package known as CPEI, the board approved proposed language to add sections 390.7 and 390.8 to Title 16 of the California Code of Regulations. During the December 16th, 2021 board meeting, the board voted to divide the CPEI regulation package into 6 packages grouped by topic. Sections 390.7 and 390.8 were grouped together. Staff subsequently renumbered these proposed sections as 384.1 and 384.2 to place them within the board's disciplinary regulations. Section 384.1, sexual contact with patient, would require any proposed decision or a decision that contains any finding of fact that a licensee engaged in any act of sexual contact as defined in Business and Professions Code Section 729, Subdivision C, to contain an order of revocation. A proposed decision shall not contain a stay of the revocation. Business and Profession Code Section 729, Subdivision C3 and 4 states, 3. Sexual contact means sexual intercourse or the touching of an intimate part of a patient for the purpose of sexual arousal, gratification, or abuse. And 4. Intimate part and touching have the same meaning as defined in Section 234.4 of the Penal Code. Then Section 384.2, required acts against sex offenders, would require the board to deny an application for licensure or revoke a license for an individual who is required to register as a sex offender pursuant to Penal Code Section 290 or an equivalent law in another jurisdiction. This section would prohibit the board from reinstating or reissuing the individual's license, issuing a stay of revocation, or placing the license on probation. Staff included a copy of the proposed language to add California Code of Regulations Title 16, Section 384.1 and 384.2, previously proposed as new sections 390.7 and 390.8. For comparison, the Physical Therapy Board's comparable regulation, California Code of Regulation, Title 16, Section 1399.15, is broader and includes any act of sexual contact as defined with any patient or any finding that the licensee has committed a sex offense or been convicted of a sex offense. The regulation then defines sex offense as the following. 1. Any offense for which registration is required by Section 290 of the Penal Code or a finding that a person committed such an offense. 2. Any offense defined in sections 261.5, 313.1, 647 subdivisions A or D, or 647B of the Penal Code, or a finding that a person committed such an offense. 3. Any attempt to commit any of the offenses specified in this section. And 4. Any offense committed or attempted in any other state or against the laws of the United States, which, if committed or attempted in this state, would be punishable as one or more of the offenses specified in this section. So for the purposes of today's discussion, the committee is asked to review this previously approved language and provide feedback to staff on whether any changes should be made. So I'll turn it back over to the committee now.
Okay, thank you. Discussion on the part of the board?
I have a question as to, does this remove any discretion on the part of the board effectively in reinstating a license for somebody convicted as or currently registering as a sex offender? Is that?
They want you to run it.
That is what that language does there in 384.2. So for the first portion of the language, sexual contact with a patient mandates that the proposed decision include the order of revocation with no stay, but it leaves the discretion of the board to order revocation with a stay. But then in the second portion of it for required actions against registered sex offenders, if it meets that criteria, as it's currently drafted, it's a shall. And as far as the purpose behind bringing this to discussion before the committee today is really looking at some of the language that other boards have. It's a little bit broader and it's not solely focused on the registration status of sex offenders, but it's more like the example that was given about the Physical Therapy Board. It's centered around sex offense, and then it defines what that term means. and it even goes as far as to include any attempt to commit an offense. So it's broader, but that language also is then phrased where it directs the administrative law judge must include an order of revocation, but it keeps the discretion with the board for whether it's an order of revocation with a stay or outright. So this language itself is kind of where we were at, and then purposes of discussion today is, we want to explore something similar or if we want to just move forward with the language that had been previously voted on by the board.
Thank you.
So do I understand you that that 384.2, from the way that I read it, it prohibits the board from reinstating or reissuing the individual license, issuing a stay of revocation, or placing the license on probation. So if they have to register as a sex offender, period, they lose their license. Is that correct?
Correct. Yeah, as drafted.
And then 384.1 is the discretion of the board.
That's correct.
Has some discretion or some latitude.
Correct. With 384.1, the board retains discretion. The administrative law judge would not have any discretion because there would be a regulation that requires that if they make the finding that the licensee is engaged in any form of sexual contact, their decision or proposed decision shall be an order of revocation with no stay. But then the board would have discretion. But then when the other section about requires actions against sex offenders, there's no discretion for either party, the ALJ or the board, shall result in revocation, and you cannot reinstate the license.
Well, that gives me a little bit of pause, that how strict that is on 384.2, because I know of situations where people have had to register as sex offenders because they were kind of forced into a position for where there was no, like, for example, I know of a gentleman that was at a concert, and things got backed up at the bathrooms, and he had a little bit to drink, but he went and relieved himself in some bushes, and he got arrested for indecent exposure. He didn't, and he ended up settling out of court because he couldn't afford to defend himself. So I look at that guy and I think he had to register and I don't know if maybe the law has changed since then. This is a number of years ago, but he had to register as a sex offender, and he was a chiropractor. He would have lost his license and the circumstances around that. So I just that gives me a little bit of pause. If we don't have discretion of a circumstance where a person had an offense, in their life, and then, maybe 10 years earlier and was still having under those circumstances. Is there any wiggle room on that as far as like language for extenuating circumstances, or is that what we can have discussion about right now and incorporate that if we feel it's necessary?
That's the purpose of today's discussion here is in the way the language is currently written, there is no discretion. Kind of looking at the example of the physical therapy board's regulation, it's very clean. It's all within one regulation. So they've actually combined the concepts of sexual contact and sex offense into a singular regulation. And what they've mandated is that the proposed decision by the ALJ shall not include a stay of the revocation, but then they're retaining the discretion at the board level that isn't currently within this draft language we have. And I'd have to defer to one of the actually three attorneys on the line about sex offenses themselves, but I believe there have been some modifications to those registration requirements where, in more minor circumstances, they no longer result in the lifetime registration requirement that previously was in effect.
Okay.
Yes, this is Sabina. I know a little bit about it. Maybe Heather or whoever else is on here would know a little bit more, but I know there's now tiers. So there's 3 tiers of these offenses, and they result in different types of and different lengths of period of registration. So I know they have been doing some update to those type of that penal code section.
So yeah, but even with those updates, if according to this 384.2, if they even have a lower tier and they're required to be on the list for 2 or 3 years, that person would effectively have to be, have their license revoked for the time that they're on the list, correct?
If the requirement is just purely that they have to register, then yes. And I'm not sure, I can't recall if any of my other healthcare boards have taken into account the different tiers. I'd have to go and look. And that is something we can go and look and bring back to you. I'm sure maybe Heather might be aware of what other boards have been doing in terms of that.
I personally would think that would be helpful for us to have a little bit of discretion depending on the tiers. I think that would be important.
And this is Heather. I do know that there was a couple of bills that have just been passed in the past couple of weeks. Pan had one about some sexual offender things. So we could take a look at that to see if there's anything we can pull from there.
Thank you.
I would like to see that, and I think retain the ability to align with that. We can revoke as long as they're registering as a sex offender, but then also retain some discretion. Because I think along the list of what Dr. Adams mentioned, I seem to recall hearing too, like urinating in public and some other kind of more misdemeanor type offenses where they had to register.
A stop on the subway, Houston.
Yes, this is. Oh, sorry, Mr. Sweet. Go ahead.
No, I was just going to say that I agree. I'd rather that we have a little bit of discretion rather than removing that discretion.
Great. Well, I will, at least on my behalf, I will make sure I send over to Ms. Walker what my other healthcare boards are doing, and that way we can compile a little bit more information to bring back to you next time.
Excellent.
Yeah.
Okay. Any other comments? Any other questions of Ms. Pitto? Okay, thank you. So let's look at what is it that you're wanting from us today, Ms. Pitto or Ms. Walker, relative to a motion, if necessary, or is this much like the last one where you're framing things, or do you want us to? It looks like we're suggesting staff to look at some information about 384.2. I think we're all okay on 384.1, but on 384.2, so maybe we give a little direction to staff to bring back some language the next time that might clarify that.
Correct. Yeah, we have. I'll defer to Sabina if she thinks a motion is necessary. I don't think so. We have the feedback there. What we were trying to get from the staff perspective was there was this previously approved language that was part of CPEI, and we wanted direction from the committee on whether to proceed on that course based on that language, or if you want us to bring it back and take some additional items into consideration. The committee had kind of the same concerns the board had, or the board staff had, about eliminating the discretion there in 384.2. So we will work on updating some language that reflects kind of the discussion today. We're also going to gather that additional background information on what's going on with the other programs and kind of structure, and we'll bring it back. So I don't think a motion is necessary unless Ms. Knight disagrees.
No, like our previous board item, we had great discussion and a lot of information to take back, and then we'll conduct that research and rework some language. Maybe we'll come up with a couple different versions to present next time.
Excellent. Outstanding. Okay, with that, let's open for public comment.
And this is the moderator, and we have opened up the WebEx Q&A feature to facilitate public comment. If you've got a comment on this discussion, you can look for the question mark icon, typically in the lower right corner of your WebEx screen or behind the 3-dot other options if you're on a mobile device. Type comment in the text box and click send. The other option is to click the raise hand icon, and each speaker will have 3 minutes. And I see no requests for public comment. Shall I close that feature?
Yes, thank you.
You're welcome.
Okay, agenda item number 7, public comment for items not on the agenda. Ms. Walker, has there been any written comments that have been submitted or received by the staff?
No, we haven't received any comments for today's agenda.
Members of the public, you may address the committee at this time. Advise the public that identifying themselves is voluntary and their name will be recorded in the official minutes of the meeting if it is provided at that time of their comment. So is there any discussion about public comment on items? I guess we'll ask the public for any comment.
Yes, and we've reopened the Q&A feature of WebEx for suggestions about future agenda items or comments on items not on the agenda. My apologies. You can look for the question mark icon, type the word comment and click send, or you may raise your hand by clicking on the hand icon. If you are a call-in user, you can use *3 to raise your hand. And I see no requests for public comment.
Okay.
Shall I close that for now and then reopen for future agenda items, I suppose?
Yes, let's do that. Is there open to the committee for any future agenda items to discuss right now?
Have none.
Is this an appropriate time, since we have a little bit of time before the end, to schedule our next meeting, or should we do that through Doodle Pool?
We have the committee's next meeting is already on the calendar for December. If I can get the current schedule here, just a moment.
That's right.
The next committee meeting is scheduled for December 9th. And then at that meeting, we'll include an agenda item to schedule out into 2023.
Fantastic.
We had a legacy item from a CE committee meeting that we regarding that was requested to be moved to enforcement.
Oh, that's right. The issue of
repetitive continuing education.
That's right. Should we address that now?
I think I would just suggest that we look at those meeting minutes and that be moved to a future agenda item for enforcement.
I also think that it was also about the time too, right? It was looking at 3 or 4 years or 5 years, MBCE, yeah. And then 3 or 4 years versus since we addressed the not repetitive already, that kind of takes care of that side of things. So
yeah, I don't think we defined. I think we defined it for licensees, but not necessarily for petitioners. And so that's why we thought it might be best as an enforcement agenda item. So maybe we could add that discussion as to, allowing or disallowing repetitive CE courses for petitioners with multiple years of, continuing education cycles. And then there was a second part to that too, but.
And then the timeline, for NBCE to have to take part 4. So I think we were talking about 5 years.
No, the second issue was, well, that may be a third issue, but the second issue was potentially limiting the amount of time that a petitioner would have to make up CE for. So let's say they're,
3 to 4 to 5
years.
years.
Yeah, that was the second. So I think those might be 2 separate discussions, one on the allowing the repetitive CE, and then the second being potentially setting a maximum number of years to make up the CE.
Is that sufficient for you, Kristen, for an agenda item for December?
It is, yeah. If the committee would like to discuss it in December, we can add it. I also wanted to point out, as part of the CPEI regulations, we've got a number of proposals within that are kind of now been separated. One of the proposals does address the petition process itself. So as far as we can either have a separate discussion solely on the issue of repeating courses and identifying the criteria, or we can set it more broadly to just talk about the petition process as part of the CPEI regulations, and we can incorporate kind of the feedback from that committee as part of that discussion. So it can go either way, but we've got it noted.
I think that makes more sense to put it under that, because that's going to fall under that umbrella, and then we can just address it in that language rather than having a whole separate section on that.
Agreed.
I think that makes more sense. Okay, yeah, that'd be great. Put that under that particular heading of the CPI aspects on license renewal, or not renewal, but reinstatement. Yeah. Okay. Anything else from the committee on future agenda items? Okay, let's open it for public comment. If there's any public that needs to, or did I already do that? I can't remember. Did I already do that?
I mistakenly introduced it early. This is the time when people can suggest future agenda items for future meetings. We've opened up the WebEx Q&A feature for public comment. Look for the question mark in the bottom right of your WebEx screen, or you may raise your hand by clicking on the hand icon, and call-in users can press *3 to raise their hand to suggest items for future meetings. And I do have a request for comment from Dr. V. I will send you a request to unmute your microphone, and you'll have 3 minutes.
Thank you. I just had a question on attending the board meeting. So I was informed that you had to be actually present to get credit for CE. Is that correct? I just wanted to ask Kristen that question. And if we can get credit through just having the WebEx, do I need to get a form from you? Thank you.
Kristen, you want to address that?
Sure, yeah, I'd be happy to respond to that. So as far as the board's regulation allows us to grant CE credit for attendance in person at a board meeting that contains petition hearings on the same agenda. So unfortunately, today's committee meetings are not eligible for CE credit, but if you monitor our meeting calendar, if we have an in-person full board meeting that also contains hearings on petitions for either reinstatement or reduction of penalty, at that point, you would be eligible for continuing education credit. Thank you.
And to that point, I think that we do have a petitioner hearing coming up in the next couple of weeks on that Wednesday. Is that correct? That's going to be a day designated for petition hearings?
We do, but it's not an in-person.
Oh, that's right. It's not in person.
Event. Yeah, we're going to be holding that by WebEx.
That's right. So that will happen next year. That's correct. Okay. All right. Thank you for your comments.
And I see no further requests for public comment. I can close the Q&A.
Thank you. Okay, that brings us to agenda item 9, and I believe that is adjournment. Slightly ahead of schedule, 5 minutes ahead. All right. If there's nothing further, we will move to adjourn. So do we have to get a motion on that? Motion to adjourn, or could I just adjourn?
No, you don't need a motion to adjourn.
All right. Everyone have a great day. Thanks for all your input, and enjoy the rest of your night.
Thanks, everyone.
Thanks, everyone.
Good night.